Man, I still love that song. That is still good stuff. Everybody, welcome to another episode of Classes of Mail. My name is Alan Gigax, and today we are going to continue reading from the JCAM. We are in Season 6 of Classes of Mail, and we are reading the JCAM again from cover to cover. So today I looked a little bit in advance to see how long each article is. And it looks like we're going to get from Articles 2 through Article 5. So 2, 3, 4, and 5. So let's go ahead and get started. Article 2, Non-Discrimination and Civil Rights. 2.1, Section 1, Statement of Principle. The employer and the union agree that there shall be no discrimination by the employer or the union against employees because of race, color, creed, religion, national origin, sex, including pregnancy, age, or marital status. In addition, consistent with the other provisions of this agreement, there shall be no unlawful discrimination against individuals with disabilities as prohibited by the Rehabilitation Act. See memo page 139. 2.2, Section 2, Committees. There are established at the national and area levels joint committees on human rights. Well, news to me. I wonder if any of my listeners are on the Joint Committee on Human Rights. The committees will be composed of a representative of the union and a responsible management official. The committees may develop affirmative action proposals on all matters affecting minority groups. The committees will also be advised of the plan for site selection for facilities planned for national postal mail networks and major metropolitan areas, and review availability of adequate housing and public transportation. The committee shall meet as required at mutually agreeable times. So I wonder, when is the last time one of these committees met and what sort of work they do? I don't know. So we had new S&DCs, for example. Did these committees meet to determine, at least in part, where those facilities should be located? I don't know. 2.3, Section 3, Grievances. Grievances arising under this article may be filed at formal Step A of the grievance procedure within 14 days of when the employee or the union has first learned or may reasonably have been expected to have learned of the alleged discrimination, unless filed directly at the national level, in which case the provisions of this agreement for initiating grievances at that level shall apply. The preceding article, Article 2, shall apply to city carrier assistant employees. And now we get to the JCAM's commentary. Article 2 gives letter carriers the contractual right to object to and remedy alleged discrimination by filing a grievance. Grievances alleging discrimination may be filed directly at formal Step A of the grievance procedure. However, if a grievance concerning discrimination is filed at informal Step A instead, it is not procedurally defective for that reason. Additionally, in accordance with federal law and regulations, letter carriers have legal recourse to remedy alleged workplace discrimination through the EEOC and the federal courts. Article 2 also gives letter carriers the contractual right to object to and remedy alleged violations of the Rehabilitation Act through the grievance procedure. Postal Service guidelines concerning reasonable accommodation are contained in Handbook EL 307, Reasonable Accommodation, an Interactive Process. That's probably a handbook I should read at some point. Look for that in Season 8 of Classes of Mail. I don't know. There's so much material to get through. There's so much stuff to help us learn. And the nice thing about the podcast is that once it's out there, it's out there. And anytime somebody wants, a relevant section of the ELM, they can find that appropriate episode of Classes of Mail and listen to that section of the ELM. So we're going to keep doing this. All right. The Memorandum of Understanding represented or reprinted below is incorporated into the national agreement. It establishes specific obligations concerning the Postal Service's duty to reasonably accommodate deaf and hard of hearing employees and applicants under the Rehabilitation Act. And here we have that memorandum between the USPS and the NALC regarding deaf and hard of hearing, reasonable accommodation for the deaf and hard of hearing. Management's responsibility. Management has an obligation to reasonably accommodate deaf and hard of hearing employees and applicants who request assistance in communicating with or understanding others in work-related situations, such as A. During investigatory interviews which may lead to discipline, discussions with a supervisor on job performance or conduct, or presentation of a grievance. B. During some aspects of training, including formal classroom instruction. So in reference to B, when I was a Carrier Academy instructor, I had a deaf student, and it was so difficult to train the student on the scanner because in order to know what I'm talking about, you have to be looking at the scanner. But the deaf student can't look at the scanner and hear what I'm saying because they're deaf. They have to be looking at me or looking at the interpreter to know what I'm saying and then look at the scanner. And it really made the whole process more difficult. The other thing that made it difficult for me is because I am incredibly immature. There's a dog bite video that we watch, and it talks about how to defend yourself against dogs and what to look for and things like that. And the video was being interpreted by the sign language person, and they're giving all the signs. And I know there's a part coming up in the video where they talk about using the satchel. And they say that, like, if the dog wants to bite the satchel, let it bite. You can keep the dog interested by lightly jerking it while it's in the dog's mouth. And I always laugh at that. I always laugh at keep the dog interested by jerking it. And as this point is coming up, I know that the interpreters are going to have to sign this, and I just imagine them when the guy says jerking it in the video that they're going to make the jerk off motion with their hand, and I just start cracking up in anticipation of this happening. And then when we got to that part of the video, the interpreters, what they actually did was like they had their hands out like they were holding a satchel. And then when it said jerking it, it's referring to the satchel. And so they just like move their hands back and forth to simulate jerking the satchel. So it was disappointing. But anyway, so that's accommodation of deaf part B. C, during portions of EAP programs and EEO counselings. Remember, these are all the times when a deaf person can have accommodation of like an interpreter. D, in critical elements of the selection process, such as during testing and interviews. E, during employee orientations, safety talks, CFC, and savings bond drives, kickoff meetings. F, during the filing or meetings concerning an employee's OWCP claim. Reasonable accommodations must be approached on a highly individualized case-by-case basis. The individual's input must be considered prior to making a decision regarding accommodation. Implementation. This obligation is met by selecting an appropriate resource from the variety of resources available. In selecting a resource, the following, among others, should be considered as appropriate. The ability of the deaf or hard of hearing employee to understand various methods of communication and the ability of others to understand the deaf or hard of hearing employee. The importance of the situation as it relates to work requirements, job rights, and benefits. The availability and cost of the alternative resources under consideration. Whether the situation requires confidentiality. Available resources which should be considered include A. Installation heads are authorized to pay for certified interpreters. Every effort will be made to provide interpreters when deemed necessary by an application of the principles set forth herein. B. In some states, the Division of Vocational Rehabilitation, DVR, provides interpreters at no charge. When a decision is made that an interpreter is the appropriate accommodation and a DVR interpreter is not available, other methods of securing an interpreter should be used. C. Volunteer interpreters or individuals skilled in signing may be obtained from the workforce or from the community. The skill level of such persons should be considered. D. In some situations, written communications may be appropriate. The deaf or hard of hearing employee's ability to understand written communication should be considered. E. Supervisors, training specialists, EAP, and EEO counselors may be trained in sign language. F. Deaf or hard of hearing applicants should normally be scheduled for a specific examination time when an interpreter will be available. G. State or federal relay services may provide a way for a deaf or hard of hearing employee to conduct postal business by telephone with other employees and customers. Management will provide the following assistance for deaf and or hard of hearing employees. A. All films or videotapes designed for the training or instruction of regular workforce employees developed on or after October 1st, 1987 shall be open or closed captioned. To the extent practicable, existing films or videotapes developed nationally that will continue to be used by deaf or hard of hearing employees with some frequency will be opened or closed captioned. B. Special telecommunications devices for the deaf will be installed in all postal installations employing deaf employees in the regular workforce. Special telecommunications devices or telephone volume control devices will be installed for hard of hearing employees whenever a hard of hearing employee requests and needs such a reasonable accommodation in order to communicate by phone. These devices will be available to deaf and or hard of hearing employees for official business and in the case of personal emergencies. As appropriate, management will provide training to staff on the use of these special telecommunications devices. C. A visual alarm will be installed on all moving powered industrial equipment in all postal installations employing deaf employees in the regular workforce, or in any installation where such a reasonable accommodation is requested and necessary for a hard of hearing employee. D. Visual fire alarm will be installed in all new postal installations for which the U.S. Postal Service, as of June 12, 1991, had not awarded a contract for the design of the building, where the Postal Service installs audible fire alarms. The parties will discuss and seek to agree at the local level about the installation in such other facilities as may be appropriate. Joint labor management meetings. Discussion of problem areas with regard to the use of certified sign interpreters, enhancement of job opportunities for the deaf and hard of hearing, type of special telecommunication devices or volume control systems to be installed, installation of visual alarms or other systems such as tactile devices at other than new postal installations, and the availability of new technologies which may help deaf and hard of hearing employees perform a variety of tasks are appropriate matters for consideration at joint labor management meetings. Discussion of such matters at labor management meetings is not a prerequisite to the filing or processing of a grievance. And thus ends Article 2. And we are at 13 minutes. All right, still got piles of time. Article 3, management rights. All right, now we get a little more interesting. The employer shall have the exclusive right, subject to the provisions of this agreement and consistent with the applicable laws and regulations. Okay, I'm already going to step aside here and say that management uses the first half of that sentence. You'll hear Corey talk about this on From 8 Arbitration and other people as well. Mike Cariff talks about it, that they have the exclusive right to do whatever these rights are that we're about to list. But the second half of the sentence says, subject to the provision of this agreement and consistent with applicable laws and regulations. So they do have these rights, but they're not without limits. They have to still abide by the contract, and they still have to abide by the law. Okay, so they have, let me read that again now without my interruption. The employer shall have the exclusive right, subject to the provisions of this agreement and consistent with applicable laws and regulations, A, to direct employees of the employer in the performance of official duties. Okay, so here, this is their right to boss you around, to tell you what it is they want you to do. B, to hire, promote, transfer, assign, and retain employees in positions within the Postal Service, and to suspend, demote, discharge, or take other disciplinary action against such employees. So this one here is management's right to hire and fire and all steps in between. And I agree with Mike Cariff and now a growing chorus of other people within our union who say that management doesn't just have the right to do this, they have the obligation to do this. And when we have situations where they're consistently mandating, forcing people to work overtime who don't want it, this should be cited. This management's sole responsibility to hire people, that they're not fulfilling that obligation. Clearly they're not hiring enough people. If we keep on having to violate the contract to make people work mandatory overtime, then they need to get on the stick and do what it says in Article 3B. All right, C, to maintain the efficiency of operations entrusted to it. Dude, once again, here's one that you could cite management failing at. This ain't very efficient. D, to determine the methods, means, and personnel by which such operations are to be conducted. All right, now here's another one. They have the right to determine the way they want us to do things, but the union has a say in that. And there are mutual methods for changing our working conditions. It's not something that can be, because remember, management has to abide by the rest of the contract, and there are agreements in place that go over these things. E, to prescribe a uniform dress to be worn by letter carriers and other designated employees. So here, once again, they're prescribing a uniform to us, but they're not giving us sufficient funds to procure that uniform. And boy, is management failing at every single one of these things they're supposed to do? Well, let's look at the last one and see. C. F, to take whatever actions may be necessary to carry out its mission in emergency situations, i.e. an unforeseen circumstance or a combination of circumstances which calls for immediate action in a situation which is not expected to be of a recurring nature. So this is yet another one where management will cite an emergency that, we had 5 routes go down and that constitutes an emergency, but this part about it's not expected to be of a recurring nature, that's your argument. Is like, dude, we have 5 routes down every day. Or this happens consistently, you're not hiring enough people. And so your lack of planning does not constitute an emergency. All right. The preceding article, Article 3, shall apply to city carrier assistant employees. And now we get into the JCAM's commentary. The Postal Service's exclusive rights under Article 3 are basically the same as its statutory rights under the Postal Reorganization Act, 39 U.S.C. Section 1001E. That's another one that I'll probably read at some point, or I'll make a highlights document like I did with the ELM. While postal management has the right to manage the Postal Service, it must act in accordance with applicable laws, regulations, contract provisions, arbitration awards, letters of agreement, and memoranda. Consequently, many of the management rights enumerated in Article 3 are limited by negotiated contract provisions. And obviously, we talked about some of those. For example, the Postal Service's Article 3 right to suspend, demote, discharge, or take other disciplinary action against employees is subject to the provisions of Articles 15 and 16. Article 3.f, emergencies. This provision gives management the right to take whatever actions may be necessary to carry out its mission in emergency situations. An emergency is defined as an unforeseen circumstance or a combination of circumstances which calls for immediate action in a situation which is not expected to be of a recurring nature. Emergencies, local implementation under Article 30. Article 30.b.3 provides that a local memorandum of understanding, LMOU, may include, among other items, guidelines for the curtailment or termination of postal operations to conform to orders of local authorities or as local conditions warrant because of emergency conditions. And thus ends Article 3. Moving on to Article 4, technological and mechanization changes. This is one that's important to look up when the robots come and try to take our jobs and take over and enslave us. Both parties recognize the need for improvement of mail service. 4.1, Section 1, Advance Notice. The union will be informed as far in advance of implementation as practicable of technological or mechanization changes which affect jobs, including new or changed jobs in the area of wages, hours, or working conditions. All right, so if there's that robot uprising, management has to let us know that it's coming. Hey, in 8 months, we're going to arm these robots and they're going to start coming after you. All right. When major new mechanization or equipment is to be purchased and installed, the union at the national level will be informed as far in advance as practicable, but no less than 90 days in advance. So obviously this is when you want to start stockpiling ammunition, jumper cables, wire cutters, anything that disrupts robots. Sexy girl robots, to distract them, things like that. All right, it goes on. The provisions of Articles 4.1 and 4.2 are administered and enforced by the parties at the national level. These provisions are not properly the subject of local grievances. However, local branches should immediately bring to their national business agents' attention any matters they believe are covered by these provisions. The union at the national level will be informed as far in advance as practicable, but not less than 90 days in advance, when major new mechanization or equipment is to be purchased and installed, which will affect jobs. 4.2, Section 2, Labor Management Committee. There shall be established at the national level a joint labor management, technological, or mechanization changes committee composed of an equal number of representatives of management and union. So once again, here we have a committee. Who's on this committee? What are they doing? Notice to said committee shall satisfy the notice requirements of the preceding paragraph. Upon receiving notice, said committee shall attempt to resolve any questions as to the impact of the proposed change upon affected employees, and if such questions are not resolved within a reasonable time after such change or changes are operational, the unresolved questions may be submitted by the union to arbitration under the grievance arbitration procedure. Any arbitration arising under this article will be given priority in scheduling. Oh, great. So it'll only be a 11-month delay instead of the normal 19-month delay. Awesome. There shall be at the national level a joint labor management, technological, and mechanization changes committee composed of an equal number of union and management representatives. Any unresolved dispute resulting from proposed changes upon affected employees may be submitted by the union to arbitration. Any arbitration arising under Article 4 will be given priority in scheduling. Okay, so this is something that I remember from reading the JCAM last time, is there will be a section of the contract that I read in the box, and then there's an explainer underneath it that basically says word for word what was in the box. So no, I did not just repeat what I had just read. What I just read is written again below it in basically the exact same language. You can look forward to more of that in the JCAM. 4.3, Section 3, New Jobs. Any new job or jobs created by technological or mechanization changes shall be offered to present employees capable of being trained to perform the new or changed job, and the employer will provide such training. During training, the employee will maintain his or her rate. It is understood that the training herein referred to is on the job and not to exceed 60 days. Certain specialized technical jobs may require additional and off-site training. An employee whose job is eliminated, if any, and who cannot be placed in a job of equal grade shall receive rate protection until such time as that employee fails to bid or apply for a position in the employee's former wage level. The obligation herein set forth shall not be construed to in any way abridge the right of the employer to make such changes. Article 4.3 requires management to offer any new jobs created by technological or mechanization changes to present employees capable of being trained to perform the new or changed job. National Arbitrator Snow held in citation that the Postal Service had an obligation to offer newly created remote video encoding jobs to current employees. On-the-job training for any new job created by technological or mechanization changes shall not exceed 60 days. During training, the employees will maintain their pay rate. Rate protection. Article 4.3 provides that if an employee's job is eliminated due to mechanization or technological change, and if the employee cannot be placed in a job of equal grade, the employee shall receive a rate protection until such time as he or she fails to bid or apply for a position in his or her former wage level. The saved grade provided for in this section is governed by the provisions of ELM section 421.53. Okay, so let's say, just to further explain this, I'm a step P carrier. So carrying gets eliminated when robots take over, but there's robot servant like oiler. And so now I'm going to get trained. I'm going to be an oiler, but oilers only get paid at step L on table 2. Oh, table 2, egg. And so I don't have to take a pay cut down to table 2, step L, when I become an oiler. What I have to do is wait for another step P position to come available. And then if I don't apply for it, if I'm like, no, I'm just going to keep being an oiler, I don't need to be a greaser instead, even though greaser pays at step P, then when I turn down that step P job, they'll be like, all right, I guess you don't want step P then. And now you're down, at oiler grade and step L. So that's how that works. It probably won't come up with anybody, but we're trying to understand all this. So there we go. See also Article 9.6, which contains a general provision requiring the Postal Service to continue all the salary rate retention provisions contained in ELM 421.5. And now we get to Article 5, the next article, prohibition on unilateral action. This is also what is called the past practice article. The employer will not take any actions affecting wages, hours, and other terms and conditions of employment as defined in Section 8D of the National Labor Relations Act, which violate the terms of this agreement or are otherwise inconsistent with its obligations under the law. The preceding article, Article 5, shall apply to city carrier assistant employees. That's the whole language of Article 5. Now we get into the explanation. Prohibition on unilateral changes. Article 5 prohibits management from taking any unilateral action inconsistent with the terms of the existing agreement or with its obligations under the law. Section 8D of the National Labor Relations Act prohibits an employer from making unilateral changes in wages, hours, or working conditions during the term of a collective bargaining agreement. In citation, National Arbitrator Bernstein wrote concerning Article 5, the only purpose the article can serve is to incorporate all the services obligations under law into the agreement, so as to give the services legal obligations the additional status of contractual obligations as well. This incorporation has significance primarily in terms of enforcement mechanism. It enables the signatory unions to utilize the contractual vehicle of arbitration to enforce all of the services' legal obligations. Moreover, the specific reference to the National Labor Relations Act is persuasive evidence that the parties were especially interested in utilizing the grievance and arbitration procedure spelled out in Article 15 to enforce the services NLRB commitments. So that's what the arbitrator says. And this, you'll notice, like if you try to file labor charges, the NLRB wants you to use your internal processes first. They want you to utilize this as well, where, hey, why don't you file a grievance on that and get it resolved instead of making the NLRB do it? It goes on. So that's it for the arbitrator. Now we get back to the JCAM explainer language. Not all unilateral actions are prohibited by the language in Article 5. Only those affecting wages, hours, or working conditions as defined in Section 8D of the National Labor Relations Act. All right, so if you're going to file a past practice grievance, it's probably worthwhile to look up Section 8D of the National Labor Relations Act. Additionally, certain management decisions concerning the operation of the business are specifically reserved in Article 3 unless otherwise restricted by a specific contractual provision. Past practice. The following explanation represents the national party's general agreement on the subject of past practice. The explanation is not exhaustive and is intended to provide the local party's general guidance on the subject. The local parties must ensure that the facts surrounding a dispute in which past practice plays a part are surfaced and thoroughly developed so an informed decision can be made. Article 5 may also limit the employer's ability to take a unilateral action where a valid past practice exists. While most labor disputes can be resolved by application of the written language of the agreement, it has long been recognized that the resolution of some disputes require the examination of the past practice of the parties. Defining past practice. In a paper given to the National Academy of Arbitrators, arbitrator Mittenthal described the elements required to establish a valid past practice. First, there should be clarity and consistency. A course of conduct which is vague and ambiguous or which has been contradicted as often as it has been followed can hardly qualify as a practice. But where those in the plant invariably respond the same way to a particular set of conditions, their conduct may very well ripen into a practice. Second, there should be longevity and repetition. A period of time has to elapse during which a consistent pattern of behavior emerges. Hence, one or two isolated instances of certain conduct do not ordinarily establish a practice. Just how frequently and over how long a period something must be done before it can be characterized as a practice is a matter of good judgment for which no formula can be devised. Third, there should be acceptability. The employees and supervisors alike must have knowledge of the particular conduct and must regard it as the correct and customary means of handling the situation. Such acceptability may frequently be implied from long acquiescence in a known course of conduct. Where this acquiescence does not exist, that is, where employees constantly protest a particular course of action through complaints and grievances, it is doubtful that any practice will be created. One must consider, too, the underlying circumstance which gave a practice its true dimensions. A practice is no broader than the circumstances out of which it has arisen, although its scope can always be enlarged in the day-to-day administration of the agreement. No meaningful description of a past practice can be made without mention of these circumstances. For instance, a work assignment practice which develops on the afternoon and midnight shifts and which is responsive to the peculiar needs for night work cannot automatically be extended to the day shift. The point is that every practice must be carefully related to its origin and purpose. Finally, the significance to be attributed to a practice may possibly be affected by whether or not it is supported by mutuality. Some practices are the product, either in their inception or in their application, of a joint understanding. Others develop from choices made by the employer in the exercise of its managerial discretion without any intention of a future commitment. All right, so those are your elements of past practice. So if you're going to file a past practice grievance, you're going to want to look through all 6 of these. Or is it 5? 1, 2, 3, 4, 5 of these, and see how each one applies to your past practice. You know, like if it's playing the radio, has the radio been played frequently? Do people play the radio every day? Has management always accepted that the radio gets played? Or do they complain and tell you to turn it off every time? You know, things like that. Functions of past practice. In the same paper, arbitrator Mittenthal notes that there are 3 distinct functions of past practice. To implement contract language. Contract language may not be sufficiently specific to resolve all issues that arise. In such cases, the past practice of the parties provides evidence of how the provision at issue should be applied. For example, Article 15, Section 2, Step 3 of the 1978 National Agreement and successor agreements through the 2000 National Agreement required the parties to hold Step 3 meetings. The contract language, however, did not specify where the meetings were to be held. Arbitrator Mittenthal held that in the absence of any specific controlling contract language, the Postal Service did not violate the National Agreement by insisting Step 3 meetings be held at locations consistent with past practice. And there's a citation here. To clarify ambiguous language. Past practice is used to assess the intent of the parties when the contract language is ambiguous. That is, when a contract provision could plausibly be interpreted in one of several different ways. A practice is used in such circumstances because it is an indicator of how the parties have mutually interpreted and applied the ambiguous language. For example, in a dispute concerning the meaning of an LMOU provision, evidence showing how the provision has been applied in the past provides insight into how the parties interpreted the language. If a clear past practice has developed, it is generally found that the past practice has established the meaning of the disputed provision. To implement separate conditions of employment. Past practice can establish a separate enforceable condition of employment concerning issues where the contract is silent. This is referenced to by a variety of terms, but the one most frequently used is the silent contract. For example, a past practice providing the local union with a file cabinet may become a binding past practice even though there are no contract or LMOU provisions concerning the issue. One of my regular listeners and a friend won a grievance like this on the use of a fax machine at his station. If I remember right, management had actually taken out the fax machine, and this is how the carrier sends his grievances off to the union hall. And so the steward, and so the steward filed a past practice grievance, and management wound up putting the fax machine back. Changing past practices. The manner by which a past practice can be changed depends on its purpose and how it arose. Past practices that implement or clarify existing contract language are treated differently than those concerning the silent contract. Changing past practices that implement or clarify contract language. If a binding past practice clarifies or implements a contract provision, it becomes in effect an unwritten part of that provision. Generally, it can only be changed by changing the underlying contract language or through bargaining. Changing past practices that implement separate conditions of employment. If the Postal Service seeks to change or terminate a binding past practice implementing conditions of employment concerning areas where the contract is silent, Article 5 prohibits it from doing so unilaterally without providing the union appropriate notice. Prior to making such a change unilaterally, the Postal Service must provide notice to the union and engage in good faith bargaining over the impact on the bargaining unit. If the parties are unable to agree, the union may grieve the change. Management changes in such silent contracts are generally not considered violations if 1. The company changes owners or bargaining unit, 2. The nature of the business changes, or 3. The practice is no longer efficient or economical. The first of these has rarely arisen in Postal Service cases involving its numerous bargaining units. A change in local union leadership or the arrival of a new postmaster or supervisor is not in itself sufficient justification to change or terminate a binding past practice, as noted in the previous paragraph. All right, that was Articles 2, 3, 4, and 5. So when we come back the next time, we will do Article 6. And guys, we did it. That is another episode down. Good job, us. And dude, that's it. I will catch you all next time.